Good afternoon, everybody. Thanks for everyone for being here. I'm Jane Henniger. I'm the Executive Director of the ACLU of Indiana. And I want to welcome our panelists and our moderator and all of you to this discussion about the rights of children in the modern era in school and out of school. Just want to point out that we have, in addition to a variety of activities with the ACLU of Indiana, one of which you can sign up for today. We will be participating in the HAPA conference, which is the Health Access and Privacy Alliance. I always have to remind myself of acronyms and what they stand for. HAPA is having a conference about reproductive health and on Saturday, and so if you want to know more information about that, it's up on the table and you can sign up if you want to attend. We have a full panel of people who can provide all different perspectives on this topic, which is always fun. And we have a great moderator, Ray Steele, who's agreed to chair our panel today. And I'll let Ray take it away.
Thank you, Jane. And thanks for having me here. This is going to be a lot of fun. If nothing else, I don't have to listen to or talk about the federal government shutdown. No offense if you've been affected by that, but I'm really, really a little tired of that. My name is Ray Steele with WIBC, and hopefully you don't think, my gosh, the ACLU had to go to the bottom of the barrel. They got WIBC here. But I will do my best to, I guess, represent this position as well as it's been represented in the past by other media members. And this is a topic that interests me a lot, is the rights of children in schools. And where do those rights go? How far do they go? And our panel is made up, as Jane alluded to, a lot of folks with a lot of different perspective on this. We have Peter Elliott, who's a second-year law student at the IU McKinney School of Law, who is, I just learned moments ago, was an ACLU intern not all that long ago, too, and worked on some cases in regards to children's rights in schools. Dave Emmert, who is general counsel for the Indiana School Boards Association, who I think he has either been sued or his association has been sued by the ACLU in the past, or along those lines. Maybe it was just a threat. But anyway, he is here, and Jackie Cease is a 93 graduate. I did get your last name right, didn't I? You did. How about that? Okay. Jackie Cease, she graduated from IU School of Law in 1993. She worked with Indiana Legal Services. She was a full-time staff attorney for the ACLU of Indiana for 12 years also, and has been a cooperating attorney since 2009. So where do we start? Let's just, I guess, rights in schools goes back to the Tinker case, 1969, but I guess the interpretation is in the eye of the beholder. We'll start with Dave Emmert. There have been so many cases, and I can think of actually one that has to do with Twitter from just a few months ago in New York State that seemed to run counter to that Tinker decision. Courts have been either here or there on how far the line goes when it comes to the Constitution and when it comes to schools.
Let me say this, the courts are interpreting the Constitution. That's where student rights come from, at least students in public schools. I met Peter on the phone a couple days ago and said when you went to Cathedral you didn't have any constitutional rights. Ray Steele at WIBC does not have any. You could go back and they could collect your urine or fire you. The Constitution does not apply to the private sector. It applies to every public school, which includes charter schools. So the Constitution then simply gives expression rights, religious rights, freedom from searches and seizures, but then it's up to the courts to take that big language and build, and so I've been in the practice 35 years in school law. I was a former teacher, so I love the area. So just like Tinker created a substantial disruption standard. The administration of a public school can step in when the student's expression creates substantial disruption. Not just disruption, substantial. So you're all scratching your heads. So you got to read a bunch of court cases to see which, and more conservative courts, the conservative courts, believe it or not, have understood and really assist from the school board, school administration angle. The more liberal courts, like we had in maybe the 60s in the long hair cases, there was a constitutional right to wear long hair. In the lower circuit courts, the Supreme Court never had a long hair case. Well, that's gone by the wayside now. You can control kids' appearances a lot more. So I'll shut up to some extent, but just to Twitter, from just a black armband, the kids in Des Moines, Iowa, protesting the Vietnam War, and now we have kids bullying each other on Twitter and Facebook and MySpace outside the school boundary. So that's kind of one of the dimensions we could get into later.
Yeah, I wanted to get into that. Where is that boundary with social media? Because this case in New York that I saw from a few months ago, where a student was suspended for disrupting the learning environment was the official reason. Jackie Cease, I'll let you speak about this. What the student did was he suggested on Twitter that the school's principal be cut to balance the budget, and he created the hashtag. The hashtag he created, and since this is being recorded for posterity, I will omit the expletive. It was the S word. CNS should cut. Blank CNS should cut. That was the hashtag he created, and of course that blew up on Twitter. He was accused of disrupting the learning environment, even though it was not taking place in the school.
Right. Well, and I think that what the courts will look at when student speech takes place off of school grounds on their own equipment, their own computers, their own phones, and then they need to look at whether the student brought it onto school grounds or intended for it to be on school grounds or assumed that it would be on school grounds. And then if it gets onto school grounds, that's when you apply Tinker and the other First Amendment cases to see if it causes substantial disruption. It sounds like in that case it must have caused a substantial disruption and been brought onto the school grounds.
Again, I guess substantial is in the eye of the beholder, though. I mean, how was it a disruption to learning? I mean, did that disrupt the actual learning process? Were people checking their phones? I mean, it seems like you would have to determine a lot of things to determine just how substantial that was.
Exactly. And substantial, and the standard here is not toothless. The schools have to have some evidence that it either did cause or they had a very good reason to believe that it would cause a substantial disruption in the learning environment. And so this isn't just people, chatting in the halls as they walk past each other about something. This is, people disrupting the classroom, that kind of thing. And they don't have to wait for a disruption to happen, but they do have to have some evidence of a history of this kind of speech causing disruption in the school, that kind of thing, before they can ban the speech.
Mr. Elliott, I understand, to shift gears here from one expletive to, well, this is not really an expletive, it's just a word that some are uncomfortable with, even if it's used in a fundraising capacity, which is a case that you, I believe, did some work on. It was a boobies case, but it was in school, and it was it a fundraiser that they were doing, it was the use of the word boobies. Tell me about that case.
Well, the case involved a student that was attending school and that was part of the Fort Wayne School Corporation. The school and what the student was doing was wearing a bracelet that says "I heart boobies" on it. This bracelet is sold by an organization that sells these bracelets in order to raise money for breast cancer research. The student in question was wearing this bracelet because her mother actually is a breast cancer survivor, and she bought it in honor of her mother, and her mother actually supported her wearing it at the school. So the case sort of came down to there's the best intentions of the student and the organization who were using the word as sort of not in a substantially disruptive or vulgar way, but as sort of to use a term that's sort of in common parlance among younger people. I mean, that's I heart breasts or I heart mammary glands does not quite have the same connection to the youth that saying a word like boobies does.
Well, there are so many campaigns now that use the word boobies as part of their fundraising. This is Breast Cancer Awareness Month. We're in the midst of it right now. You're going to see that a lot. I suppose the question would be, I mean, us giggly boys in school would have a field day with that potentially, but if we use it in virtually everyday life now, what's wrong with wearing something like that in school? Dave Emmert, what's wrong with wearing something like that in school?
Well, the school has the burden to show, as Jackie was saying, where was the disruption, where's the evidence? There was a case out of, doesn't matter where, on the East Coast, where the 8th grade girl wore a T-shirt saying drugs suck. So now we've gone from boobies to suck. You didn't know this was going to be R-rated today, did you? So actually, she was suspended from school for suck because suck has a different meaning. Boobies can be interpreted. So, but where's the evidence, once again, of the disruption? Actually, the principal won because they brought in an expert witness from Duke, an English professor from Duke University, that basically said suck amongst kids has a different interpretation than maybe it did in Old English. I'm exaggerating here a little bit, but suck still had a sexual connotation, and we're not here to promote sex in schools. And so therefore, but she brought in an English professor from a private school, presented I don't know if it's jury or not, but anyhow, but that was just over suck. So boobies, now the Pennsylvania judge ruled, if I remember, the federal district court had the first boobies bracelet case, and I think upheld the girl. Now let me think. And as a matter of free speech, there wasn't enough evidence that. Then the Wisconsin federal judge, both females in Pennsylvania, and said, sure, there's evidence of these young, maturing middle school kids. The word booby can set them off and take their minds away from scholarly pursuits. And then we had one in Twin Lakes schools in Indiana, and the other, as Peter was saying, in Fort Wayne. And so a lot of this stuff depends upon the facts and how good attorney the school has. And by the way, ISBA wasn't sued by ACLU. In fact, our message is the ACLU message. We're educating board members to superintendents to principals every day on how to follow the law. So we hope ACLU does not come knocking, but they don't always call us. So a lot of our membership, we have 290 school boards in the state that belong to our organization, so that's what we try to do.
Point taken.
Help them.
I wanted to just add something about the boobies cases and the drug sex case. Those cases weren't decided actually under the substantial disruption standard of Tinker. They were decided under the Fraser standard of being lewd, vulgar, and offensive. So this is one of the ways that students' rights, First Amendment rights, are lesser than those of adults, especially in school. So in school, generally, the school can't punish their speech unless it causes a substantial disruption or is likely to. Exceptions to that, though, are if the speech is lewd, vulgar, or offensive, and that was the question in those cases, or if it seems like if it could be perceived as school-sponsored, or most recently, if it talks about drugs. So even in a positive way. So that's another. I mean, it could have been decided under Morse too, that drug sex case. But that the JA case that Pete was talking about was decided under Fraser. Under the court found that it was reasonable for the school to interpret it as being lewd and vulgar.
Could I add something on
Certainly.
back to Jackie's point about being off school property versus on? And there was a case from a circuit court in the East Coast, I think 4th Circuit, West Virginia girl, Kowalski. Now, Kowalski had a conflict. Kowalski is a female student, had a conflict with another female student. She invited 100 students to her whatever blog or whatever site it was. 23 joined, and the whole purpose was off-school property to cyberbully the student involved. And 23 kind of joined up. They accused her of whore, slut, herpes, you name it. The girl was devastated. Obviously, news of that came to school. Like Mary's little lamb, it did follow her to school. And it was that evidence that said it was reasonable to expel Kowalski for setting up really a hate site, inviting other kids because they couldn't keep it to themselves. So there was enough evidence that it had gotten to school, but really Kowalski set it all up and then claimed innocence, and the Fourth Circuit ruled that was sufficient. And so Indiana, I brought an article I wrote on the bullying bill this year. 2005, we had our first legal bully in Indiana. That's the first time we ever had a law prohibiting bullying and allowing us to discipline for bullying. Then in 2013, based upon that Kowalski case, that removed the requirement that the conduct off school property had to be unlawful as far as bullying, and now really the definition of bullying, whether it's ridicule, whether it's hate, whether it's beating someone up off school property, as long as it creates, let me get the exactly, an objectively hostile school environment. So even electronic bullying now off school property, assuming this is a constitutional statute, because that's one of the legal tensions that ACLU may pick up one of these days, they can always challenge the constitutionality. Does this deprive the right of free speech? But at least the Fourth Circuit, no, as long as it gets back to school and has a negative impact. And so Indiana built into that this objectively hostile school environment. So kids just can't bully willy-nilly on the weekends and say, ha, 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 you can't touch me on Monday morning.
That's interesting because we just had this case in Lake County, which I was reminded of, Griffith Middle School, where again, and we could probably do an entire other panel on the line between bullying and good-natured teasing, which is not the topic today. But in this case from Lake County, it was Facebook postings, and 3 girls were suspended because their Facebook postings supposedly had violated the student handbook and the guidelines on bullying and harassment. Even though the Facebook conversations took place after school, the comments and the ACLU defended the girls because they were meant to be joking, apparently, because of some of the terminology, the online terminology they used, Peter, the LOLs, LMFAOs, and eventually they won their case because they were able to
Settled.
It was settled. Excuse me. There's a difference. There's a difference. But again, that's one of those in the eye of the beholder things, I suppose. I mean, it's either bullying or it might not be bullying, and it might be on school grounds, and then again, it might not be.
Mm-hmm.
Go ahead.
Sorry.
Yeah, no, and that's definitely a major consideration that you have to take into account when you're dealing with something like bullying. I mean, it's with technology, the ability to utterly destroy someone's reputation through words is greater than ever, and that can also that could also blow back on the bulliers too. I mean, what's with Google now, and what was once something you would write on a bathroom stall disparaging someone, now you can keep forever on some server somewhere that so and so is a blank, or for anything, and it's and I think that's one of the generational issues that schools are dealing with too, just because the LOLs and the LMFAOs and the elite speak, as the kids say these days. It's sort of trying to interpret that language to see what trying to draw the line between what the student is doing and meaning while, trying not to overly encroach. Sorry.
I could add, I got that phone call from the superintendent at Griffith after they had been notified by ACLU about a potential suit. And this is from the Indianapolis Star, so we know it's going to be accurate. So this is, at least it says, but the school's argument was this. Now, I'm only hearing one side as well. When ACLU gets it, they hear another side of the story. Like that's what Peter was talking about. There's a tension here and getting at the truth. But from the school's point of view, within a span of 2 hours, there's 70 Facebook comments were posted in January of 12, including names of at least 5 people they said they wanted to kill, and discussions of using guns, knives, box cutters, and gasoline, and filling a bathtub with acid to dissolve the body. Now that's what the school was presented by the parents of one of these 5 students. Now if you're one of these 5 students, or you're the parent of one of these 5 students, do you expect the school to, the ACLU is out there, sorry, we, since this was off-school property, we can't do anything about it. After the Columbine disaster in Newtown, I mean, school people are there really to protect kids. They're there because they like kids, but they want to protect them. So here's an off-campus expression, but they put the emoticons, the smiley face, LOL, lots of love or laughter or whatever that means. So if I would have brought in, if I would have brought in a submachine gun with a smiley face on it and purposely delayed to make my point, walked in here with this Uzi, you didn't know if it's loaded or not, but I had a smiley face on it, am I protected? Well, we don't know yet. No court's made a decision, but as Peter was saying.
As long as you're laughing about it.
Yeah, if I come in ho, 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 and you don't know, I mean, everyone's going to head for cover. So that was the position, at least, that the school was in, and they made the decision on safety. We'll protect first and worry about ACLU second. But that's just one of those classic situations. It's good to have something concrete to talk about today. So.
And there's one thing that we should remember too is, it's not just the school who has a responsibility for student speech. I mean, parents, and there are laws. I mean, there are criminal laws that apply to kids too, for slander, libel, harassment, threats, what have you. There are resources like getting restraining orders against people who are harassing you or threatening you. And the key, though, for the school, I think, in these situations is it affecting the school function, the educational function? That's what the school has to look at. And if it's harassment, no matter how bad the harassment is, if it's not doing anything with the school, it's not the school's role. On the other hand, I mean, obviously, the school has not even just a moral obligation, but they have a legal obligation to protect students and to keep them safe and to keep them safe from harassment. So, the ACLU, for example, insists that schools protect gay and lesbian students from harassment through anti-bullying rules. And so, I mean, it is a fine line. There is a tension there. Everybody recognizes that. But we don't need to just look at the schools just because there are students involved.
Really enjoying our panel discussion here. I want to bring up one other thing here that the ACLU, and this also has been settled when it comes to students' rights. And I cannot believe, frankly, when I first saw this lawsuit a couple months ago, it's now a couple months ago, it was late August, that we were still fighting this battle for girls to play an all-male sport. It was a girl who wanted to try out for her high school football team, seventh grade football team, and was pretty much told by the school, by school officials there, that no, football was only for guys. And I thought we had crossed this path a long time ago, and lo and behold, it came up. Now, as I understand it, just a couple of weeks after the lawsuit was filed by the ACLU on behalf of this young lady, the school changed their mind, and she is now getting to play football, which is a very good thing. But I was frankly stunned in 2013 that this was still an issue somewhere.
We were surprised too. we were surprised also that the school didn't, once we brought it up to them, didn't settle it right away. I don't know if it took a while for them to get to their lawyers or something.
Yeah, they called me too.
Right, but I mean,
I told them to settle as fast. I'm sorry, Jack.
the law's been very,
The
the law has been very clear for quite a while on this topic. It's an equal protection claim, and girls are entitled to participate unless there is some reason why physically that individual girl is unable. Or if they can exclude girls from a boys' football team, for example, if they have a girls' football team also.
If they have a
that's
girl.
equal to the boys.
Okay. And does that, I don't think this has come up in a while, does that cross both ways? If there is a girls' volleyball team but no boys' volleyball team at a high school, for instance?
That's right. That's absolutely
Does it really?
right. Yes.
Because I recall many years ago, I grew up in Georgia, and I vaguely, and I was young, so I hope I'm not inventing this out of my imagination, but I thought I remembered a case, it was a cheerleading case, because there weren't a whole lot of guy cheerleaders back then, at least not in rural Georgia where I was. And there was a case involving a boy who wanted to be on the cheerleading squad, and they weren't letting him do that, which again, you don't think of that in 2013, but
Right.
20, 30 years ago, that was a big deal.
Right. Go ahead.
I'll just say this, under equal protection of the law, normally, if you have a logical, rational basis for what you do, the school or the government wins, just any logical basis, except if it's based upon race, religion, speech, some of those fundamental rights or suspected classes, then you've got to have a compelling governmental interest. But women were always placed, sex discrimination-wise, over with, just give us a logical reason to keep the girl off the football team. So the Supreme Court had to wrestle with this, I think, in the early 70s. What are we going to do with there's a lot of women out there in society. What are we going to do now? Are we going to give them the same status of suspect class, historically discriminated against, and then government has to give a compelling reason to keep her off the football team? Well, they gave you women a promotion, but not up to the highest level of scrutiny. Well, we're going to say it's a medium level of scrutiny, and so the government has to give an important reason, not compelling, just important enough to keep women off the team, or the boy, it's a good point, the boy off the cheerleading squad. And in this textbook, I teach for several universities, school law for future administrators, and I found a case out of the District of Kansas that I put in the book where this was the girl wrestler, wanted to wrestle in the 9th grade. Now, they let her wrestle in the 7th and 8th grade. Now she's a 9th grader. And they say, you can't even go out for the team because you're a female. And so the judge just analyzes it under that classic legal standard, took every one of the school's reasons for keeping her off and had to decide one of the things was maybe improper touching and wrestling. I mean, even boys wrestling, those hands and arms go in pretty intimate places when you wrestle. So the court basically says, yeah, preventing sexual activity is an important governmental interest, but then the state had to show why they had a strong interest here, and then the judge says, wrestling is an athletic activity, not a sexual activity. So therefore they failed to show that they were, I think, substantially related to that important governmental interest. She got to wrestle. And so I like that comparison.
I think, Dave, and you could tell me that I think that one of the reasons why some of the schools might currently think still that they can exclude girls from contact sports is because Title IX, it says that it only applies to non-contact sports. So that's a federal law that protects females in school. But that's not the Equal Protection Clause. There's still the Equal Protection Law that says under the Equal Protection Clause, even for contact sports, you can't discriminate.
Yeah, they forget about the Constitution, even though they all were supposed to have had a course and covered equal protection, and I've taught it since 1982 for IU, but they forget about those things, and they don't call. And that's why ISB has 3 attorneys on staff. If they join, we don't send them a bill. They can call us. We believe in preventive law. But Some of them don't have our number, don't call us enough. Because if they would have called, that school would have called us, we wouldn't be talking about that.
We talk about the rights of female students to play on male teams, vice versa, whatever the case may be. I know there have been some cases involving gay and lesbian student clubs, their rights. Have we had any cases, because I can't recall any off the top of my head, at least that made it to court. I've heard of people perhaps having problems with gay and lesbian students playing on sports teams just because of their own personal preference. They have these ridiculous worries about locker room situations. Have we had anything like that make it to court that you guys know of?
I am not aware of, but that
Okay.
doesn't mean that it's not.
Well, that's a good thing. As much as we've dealt with gay and lesbian student rights in school and the right of them to assemble, have their own clubs. I know there was a Gay Straight Alliance
Right.
club. I forget which state that was from, which they had to fight to get that club just even approved. And I think the school went so far they were just going to ban all clubs if they were going to be made to have the Gay Straight Alliance club.
Out in Salt Lake City.
Salt Lake City, well, of course, yeah. That's my commentary, not theirs.
Boy Scout option.
Do we have any questions from the audience today? Yes, sir.
Yeah, well, since the federal money and funding education varies quite a bit among different educational institutions, I'm wondering if any of these cases of students' rights would differ if, rather than a public school, this were a private or parochial or a charter.
I'd say
particularly
definitely,
charter
yeah.
schools.
I would just add quickly, Title IX, if you accept any $1, John and I've known John and Linda for quite a few years here. But right, so Title IX would apply to, I'm sure that Cathedral accepted some monies.
Yes.
And-
yeah.
and
that's
so
that's
that-
why I
that's-
played on the men's club volleyball team as opposed to the
Oh,
women's varsity volleyball
Yeah.
team.
Oh, I see. Okay. That must have been now-
Cathedral does not have a women's football team.
Well, obviously not. No, but
Right.
going to and I meant to bring that up, Peter. Going to a Catholic high school, a private high school, where you don't have the same kind of rights. While you were a student there, since you were the youngest amongst us here, high school is more recent for you than the rest of us. While you were in school, did anything come up as far as rights, as far as somebody deciding to protest something and getting in trouble and not having the ability to have an ACLU back them up if they wanted to challenge that?
Well, I know when I was there, that was right around when Facebook was becoming a solely collegiate thing to expanding to high schools and going on. So our class was one of the first classes to do stupid things on Facebook, as far as saying things we shouldn't and criticizing administrators. And fortunately, I had some great parents that made sure that I was smart on the internet, and I was not implicated or did anything like that. But I know a few people that they did say some things that were that it wasn't, it didn't amount to, well, first I'm going to do this and that, and I'm going to get, Walter White to give me some acid to hide the evidence. And I think if there had been, at least, if nothing else, there would have been probably more of a dialogue that would have been able to arise had the threat of litigation been there. That's not, I'm not trying to disparage my alma mater by saying that, but I think, I think it's something that you're always trying to balance as an administrator, this role of, gatekeeper and, making sure people are safe. But it always seemed like when you had no real threat of there being someone to correct, then you could sort of do what you want regardless and almost. And maybe even if it didn't seem like it, it felt like as a student your rights are being steamrolled essentially for the sake of, order.
I'll just add a legal tension that we're talking about in the office lately at a Catholic school, and the stance on pregnancy, abortion. since Title IX applies at a Catholic school, because they accept, say, math funds and science foundation funds from the government, Title IX also covers becoming pregnant in the family way. So an interesting question is, what happens when a Catholic school cheerleader gets pregnant? Title IX would apply and give rights, since they accept federal dollars. And it's clear you cannot discriminate because of that status if the person is still able to, if not tumble, at least still get out and jump around a little bit. Does she get to wear her cheerleading uniform now that it's been let out a little bit? She's obviously pregnant. She doesn't go on the pyramid anymore. And my question to public school people are, they have to be moral exemplars. Well, I said, have you ever had a football player get a student pregnant? Oh, yes. Well, what do you do with the football player? Let him play. And so that, well, you have to let the pregnant. So in terms of a Title IX issue that could possibly occur at a parochial school in terms of pregnancy out of wedlock or even had an abortion is technically protected. And whether or not, hopefully the Catholic administrators, if they love kids, are going to help the kid out. But it's just one we've.
But you would have some who would probably take the argument that, well, that violates the Catholic Church's teachings.
Well, yes. Yeah, so that's correct, and they have that right in the Constitution as well. So there's a complicated number of legal forces coming together, the perfect storm, so to speak.
Sure, sure. I mean, we have that going on. I mean, this is not within lower level schools. Brigham Young University, the football team, had a player who was just suspended from the team because he had his picture made at a bar in Las Vegas holding up he wasn't drinking it at the time, but he was holding up what appeared to be a bottle of Dom Perignon. But that violated BYU's honor code, so he was suspended from the football team for 5 games. Anyone else? We have a question back there. Yes, ma'am. If you could wait just a second, let Kelly come back there with the microphone since we are recording. Thank you very much. Go ahead.
You were discussing gay lesbian organizations, and I wondered, I assume that they have the legal right to meet because of discrimination, all that. My question is, does that change if you're in public versus private? If it's a religious school, does that change? Or if you get, I'm thinking at the high school level, but then what if you get younger? What if a 7th grade, a middle school wants to have this organization? Does that change as the age gets younger? Any of those questions?
Well, like Dave was saying at the beginning, for a parochial school, for a non-governmental entity, they're not subject to the Constitution at all. So they can generally keep out whoever they want as far from a constitutional perspective. For the gay and lesbian students in a public school, the school's obligation is to allow student groups to meet at school on the same terms as any other student group. So if the school has opened itself up to meetings of students or even meetings from outside organizations, then it can't discriminate on things like the basis of race or sexual orientation or gender. And so, I mean, I think you'll find most elementary schools probably don't have student groups like, that would meet like that, and so they probably don't have gay lesbian rights organizations. But to the extent that they did, yeah, they would have to allow that in elementary schools too.
And one addition, perhaps, under the Federal Equal Access Act back in '84 under Reagan, and that was in an era where administrators they learned, well, we can't allow religion in the schools because we cannot establish religion as the governmental entity, and administrators would forget about students' own rights, religious rights, while at that school. So to clarify that, Congress passed the Equal Access Act And just as Jackie said, but I believe that also back to recipients of federal funds, like Title IX, I think that applies, it only applies at the high school levels in each state, but public schools as well as a private school accepting federal funds, so that group at least would have the opportunity to meet like any other group would meet. Ray, there's someone behind the column there.
Okay.
Well, it's-
All right, we'll
that's-
get her first, and then we'll get to the person behind the column.
I'm sorry.
Someone have a question down here?
Oh, okay. I thought somebody.
I thought we did too.
Okay.
I think someone behind the column up there. Yes, he did. There we go.
Hey, Dave, I want to maybe just continue on the equal access law a little bit. As a religious minority, I'm always attuned, especially with young kids going into public school in a couple years, attuned to sort of the issue of freedom from religion. So I obviously know a little bit about, flagpole ceremonies, students having the ability to pray in groups, but privately, access to facilities if the school opens it to other organizations. My question is that it's my understanding that at least one school district here in the greater Indianapolis area lets in a religious organization into the school cafeteria to set up a table. They go through background checks, the staff members or things like that go through background checks, and they're there during school hours in the cafeteria while their students are there and have the ability to talk to students during school hours. So I guess I'm just curious where maybe some of the case law stands on issues relating to that and what you guys are advising school districts on as far as letting in organizations like that during school hours.
There's a lot of case law out there. If the public school administrator gets too friendly with religious groups and religious parents, and if they let them in as a privilege, and it's not like you had a vocational day so pastors could come in and what it's like to be a pastor, and you had an open forum set up. But if that's clearly government nodding its head, come on in, just a head nod, to me that becomes government sponsorship, promotion of a religious activity that we haven't talked about yet. Another element of the First Amendment is freedom of religion, but freedom from religion as far as the government sponsoring and promoting. So well, if I got that call, I'd first, you do it just for the religious group? Why do you do it? When do you do it? Is that just Monday and on Tuesday some other groups can come? I mean, you'd have to analyze it, but that's highly suspect.
And to the extent some, for example, a group of atheists wanted to come in, if once the school is allowing the church to come in, well, then they can't say no to the atheists, or so and that would set up a case, a lawsuit.
Just to follow up without the mic, I don't know exactly what that discussion is. It's my understanding that a lot of it is like, come join us and play paintball on the weekend with us, and while we're playing paintball, we'll have a discussion about, God or religion or whatever. So I just didn't know sort of where the fine lines were on situations like that.
It's like they weren't necessarily preaching to them in the school, like they were inviting them to church, essentially. Okay.
And the question, too, becomes, if you allow outside groups into your facilities in the evenings or weekends, so if you let 4-H or the Scouts in, the Good News Clubs, there's a U.S. Supreme Court case where a school banned, we can't let a religious club in. We'll let non-religious clubs in after school or, independence. And the Good News Club prevailed because you've opened up your forum either on a Saturday or Sunday afternoon for any other activities than merely a business relationship with a religious group. Some churches just getting formed or the church burns down will have a business relationship, pay for the custodial overtime and rent the facility. Well, if you rent it to others, it's okay to rent it to a church as well. I mean, that would be all right. You're not definitely trying to promote religion per se.
Sorry, so you can go to my hometown, Trenton, Georgia, and still start an argument about praying at football games.
Oh.
And it would last until Sunday, probably. Any other questions?
It's funny because it's been settled.
Yeah, I know, it's been settled. Yeah. Not in my hometown, it hasn't. Got a question down here.
With so much Indiana state money now going to private schools, in the voucher program. Does this put those private schools under scrutiny? It's state money.
It is public money, yeah.
I'm pausing initially because, I mean, you could think of something back to John Harper's first question about federal monies usually wind up first at the Department of Education before they're channeled out to schools. Now, I don't know. We'd have to analyze it because whether or not Title IX would apply or not. Now, simply because it's governmental money, I do know the voucher monies, those schools have to be certified, accredited by the Department of Ed and go by those standards. And that's Indiana legislation. And subject to review the charters or even the Catholic Lutheran schools that accept vouchers. But I think they're pretty much accredited already, so there's no issue. But I've never seen a case yet of maybe Title IX monies, somehow that would make a school subject to Title IX that wasn't.
Or even is it subject then to the Constitution? I mean, it's an interesting question, and I don't know.
Right.
I would think that you could, well, probably depending too on how much money they get from state money from vouchers or government money.
Yeah, what makes it a public? Yeah, that's a good question.
It would be arguably.
Isn't that one of the arguments that those who were challenging the voucher law attempted to use before the Indiana Supreme Court, and the Indiana Supreme Court turned them down in legalizing the voucher program? Yes, ma'am.
Actually, the Indiana law, the Indiana Constitution, is very strong on this. In some respects, almost stronger than the federal one, where it says that funds should not go to support religions.
Yeah, it says, no money shall inure from our treasury for any religious purpose. And so we thought we had a shot at that. We public educators saw it, but our court, still unanimous, I believe, discounted that. Because the money went to the parent, really, even though it was written to the parent and Cathedral High School, or whatever. But so that got, supposedly that was important to the Supreme Court. It really went to the parent for a private purpose.
Okay, so I just wanted to ask the question of the panelists that since we are on the precipice of many technologies right now that have the potential to peer into the lives of students and give the government that opportunity, and we've seen recent cases with the NSA and other federal organizations who have taken those liberties. What are the implications for students, and what rights do students have that are specific to them, or children? What rights do children have that are specific to them? That protect them from those kinds of intrusions. And I'm talking not only about video recording, but also maybe chipping with radio frequency identification chips and GPS tracking with their cell phones. So there's so many different aspects to the technology. So how will students be able to fight back?
Well, I mean, the latter question, it's not the government chipping, so that would be a problem. You know, that would be parents' decisions, or if they're going to be tracking their kids on a GPS, that would be a private matter. But as far as technology in school, it's you have to. Generally, it comes up in school if the school is wanting to punish a student for some sort of speech that it made, either on their cell phone or on a computer, on Facebook, on Twitter, or something like that. And again, it comes back to the same standards, the same First Amendment standards. So, for example, with cell phones, a school can take the cell phones and give them back to you at the end of the day because you're not allowed to have cell phones. But then they can't get on your cell phone for no good reason and start reading through, trying to look for things. That's an invasion of students' privacy. So, students still have privacy rights, and all of their privacy rights and their First Amendment and Fourth Amendment rights still apply to technologies in the school.
So really, and that the Supreme Court, rather than the probable cause standard that the police have in 1985 in the TLO case, the search of a girl's purse for just regular cigarettes, the school just needs to have, as a government, reasonable suspicion to believe that the cell phone, but still, and there was just the First Circuit, Sixth Circuit Court of Appeals in the last 6 months. That's the first student cell phone case to get to the circuit level where they had no cause, no suspicion to open up that, well, the kid might have been thinking of committing suicide. We wanted to help the kid. I mean, the school gave these specious arguments. Well, might have had friends who dealt in drugs. We just wanted to read those Didn't work. They didn't have specific information. So the Fourth Amendment was important.
And generally under the Fourth Amendment, the search itself has to be reasonable, and to be reasonable, it has to be justified at its inception, and then reasonable in scope. To be justified at its inception, there has to be an actual reason to believe that particular student broke a particular school rule or law. The school can't just go on fishing expeditions and say, well, the school or the student looked like they were doing something wrong.
We can't just say, we're looking for the terrorists.
Exactly.
Like the government
You look
does
like
sometimes. Yeah.
For now.
Okay. Well, I think, unfortunately, our time is gone. I want to thank Peter Elliott, Dave Emmert, Jackie Cease for being with us today. And much thanks to the ACLU for breaking me away from the State Board of Education meeting, which is going into hour number 4. They call that warming up in the bullpen, I think. But thank you very much to the ACLU, and thanks to everybody for coming today.